Okay, good afternoon. We're about 4 minutes into the hour. We'll get started. Welcome to the Office of Family Assistance's webinar, summary of TANF, NPRM, and instructions for submitting comments. Okay, next slide. We thank you all for tuning in today. Today's session will be recorded and posted after to the PRTA and OFA websites. We appreciate all that you, our grantees and partners, do to support children and families served by the TANF program, and we thank you for your willingness to consider collective efforts to strengthen the program. As we hope you are aware, ACF published a Notice of Proposed Rulemaking entitled Strengthening TANF as a Safety Net and Work Program on October 2nd. The NPRM is intended to strengthen TANF's role in supporting family well-being and work, as well as creating additional accountability for states to ensure TANF funds serve their intended purpose while maintaining state flexibility. Next slide. Comments are due December 1st, 2023. HHS welcomes comments through the comment process from all interested parties and will closely review and consider every comment it receives. Our goal for today is to make sure the public has a better understanding of the changes that HHS has proposed to the TANF regulations in its NPRM, and that everyone knows how to submit a formal comment if they wish to do so. We are not taking any questions or comments today during this webinar because we want to ensure that all of your thoughts are properly documented in the official rulemaking record so that HHS can appropriately consider and address all of the relevant issues. We appreciate that in proposing these changes, there may be issues we have not fully considered. We strongly encourage your input informed by your experience with the TANF program through the formal comment process. Next slide, please. The announcement for this webinar had a link to the NPRM in the Federal Register, and a URL is also listed on the slide. There is an option to submit a comment straight from that site. The link to submit in the federal e-rulemaking portal of regulations.gov is also included. We remind you that all comments received will be posted without change. I will now turn things over to my colleague, Deborah Liss, who will walk us through the package of proposed changes.
Thank you, LaShira. Next slide, please. This is the package of 7 regulatory proposals that are included in our Notice of Proposed Rulemaking. I will now walk through each proposal. Next slide, please. Just a quick note before we go forward that the proposed changes are limited to state regulations at this time. This NPRM does not propose any changes to the tribal TANF regulations. Prior to any changes in tribal TANF regulations, we will engage in tribal consultation. Next slide, please. The first 2 proposals, both related to allowable spending, would clarify the criteria HHS will use when applying the misuse of funds penalty. These proposals would help ensure that states expend TANF funds in accordance with the statute. The first proposed change would establish a federal limit on how states may define the term needy. The TANF statute specifies that expenditures under TANF Purpose 1 may only be made for needy families, and TANF Purpose 2 may only be made for needy parents. Generally, maintenance of effort, or MOE, must also be spent for needy families. This proposed change would require that state definitions of that term needy with respect to all federal TANF and state MOE expenditures that are subject to a required need standard must be limited to individuals and families with incomes at or below 200% of the Federal Poverty Guidelines. States may continue to establish different standards of need for different services limited to needy families, but for this proposal, all must be at or below the 200% of the Federal Poverty Guidelines. The proposed change would not impact the need for income verification, and therefore we do not expect it to create significant additional administrative burden. As we wrote in the NPRM, we solicit comment on strategies for minimizing administrative burdens in the implementation of this proposed ceiling on the term needy. We believe that limiting the definition of need to 200% of the Federal Poverty Guidelines is consistent with the intent of Congress in establishing TANF, and more information about this is in the preamble text. HHS did consider alternatives to this proposal, including determining a standard of need that varies according to the state's cost of living, an index of the average state median income, as well as other possible limits on the term needy, such as limiting the term to families below 130% of the Federal Poverty Guidelines. We welcome comments on the proposed limit of 200% of the Federal Poverty Guidelines. Next slide, please. The second proposed change seeks to clarify how the term reasonably calculated to accomplish a TANF purpose applies. This proposal sets forth the standard HHS would apply to determine whether expenditures are or are not reasonably calculated to meet a TANF purpose and thus warrant a penalty under the Misuse of Funds Penalty Authority. In accordance with the reasonably calculated language of the statute, we propose in this rule to describe the applicable standard as a reasonable person test. This is the same standard that our regulations have used since 1999 for determining whether a misuse of funds is intentional. In many instances, the analysis will be entirely straightforward because certain expenditures clearly fall within the plain language of the statutory purpose. For example, cash assistance for needy families, employment services for needy parents, and teen pregnancy prevention programs clearly fall within the express statutory language of TANF purposes 1, 2, and 3, respectively. However, in other instances, a question may arise as to whether an expenditure is reasonably calculated to accomplish a purpose of TANF. In such cases, we will consider a number of factors that are laid out in the preamble text. These include things like evidence that the expenditure actually accomplished a TANF purpose, as well as academic or other research indicating that the expenditure could reasonably be expected to accomplish a TANF purpose. As with any situation, the analysis will necessarily be fact-specific. We note in the preamble that there are several forms of evidence that a state might provide to support its justification for a TANF expenditure. The preamble also provides more information about how we would determine whether an expenditure is reasonably calculated under the reasonable person standard. As we wrote in the preamble, we do not consider the examples to be an exhaustive list. We welcome comments on the examples and the potential impacts on financial management and reporting, as well as on service delivery and program operations. Next slide, please. The third proposed change would exclude the following as allowable TANF maintenance of effort or MOE expenditures: cash donations from non-governmental third parties and the value of third-party in-kind contributions under TANF. HHS has authority to regulate what counts as MOE consistent with the statutory framework in order to enforce the MOE penalty and to determine how MOE expenditures factor into the caseload reduction credit. This proposed change would ensure that states themselves are investing in TANF programs and maintaining their own financial commitment to needy families, as intended by Congress, while maintaining state flexibility. As we wrote in the NPRM, we invite comment on the effects that this proposed change would have on state programs, budgets, and partnerships. Next slide, please. The fourth proposed change would ensure that, when determining engagement toward the work participation rate, excused holidays match the number of federal holidays. following the recognition of Juneteenth as a federal holiday. As laid out in the interim final rule of 2006, states can count paid employment hours toward the work participation rate by using the hours for which the individual was paid, which therefore allows paid holidays to count. The final rule of 2008 set the number of holidays at 10. In 2021, the Juneteenth National Independence Day Act established June 19th as an 11th legal public holiday. Therefore, under our authority to issue regulations on how to count and verify reported hours of work, this proposal would realign the TANF rules with respect to holidays to the number of federal holidays. As under current rules, each state must designate in its work verification plan the days that it wishes to count as holidays for those in unpaid activities. HHS encourages states to honor our newest public holiday by granting Juneteenth itself as an excused day for TANF participants in unpaid activities. Next slide, please. The fifth proposal would develop new criteria to allow states to use alternative income and eligibility verification system, or EVES, measures. As you are likely aware, EVES is a set of data matches that each state must complete to confirm the initial and ongoing eligibility of a family for TANF-funded benefits. Currently, a state may request approval from HHS to use an alternate source or sources of income and eligibility information to meet any of the EVES data matching requirements. The state must demonstrate that the alternate source is as timely, complete, and useful as the data provided by the original source. When considering applications, we have noticed that this standard is very difficult to meet, particularly with respect to requests for alternatives to the IRS unearned income data. States have also repeatedly noted that some of the required EVES matches, and especially the match with unearned income data from the IRS, are administratively burdensome and neither cost-effective nor programmatically useful. We propose to modify the criteria for alternative sources of EVES data matches so that they are more reasonable and factor in cost effectiveness. Specifically, we propose to allow a state to request to use an alternative data source that is as cost-effective rather than as complete as the original source. We would continue to require any alternate data source to be both as timely and as useful as the original source. As we wrote in the NPRM, HHS welcomes comments on the current administrative burdens, including cost and time estimates, and usefulness of the required EVES matches. We also welcome comments on the benefits that might be gained from using more cost-effective alternate data sources. Next slide, please. The sixth proposed change would clarify the significant progress criteria following a work participation rate corrective compliance plan. As you are likely aware, in the case of a state's failure to meet their work participation rate requirement, the law provides for a single penalty, even though there are two separate participation rates, the overall rate and the one for two-parent families. This proposal would clarify the formula for recalculating a state's penalty in a situation where a state that failed both the overall and two-parent rates for a year subsequently meets the overall rate, but not the two-parent rate as part of its corrective compliance plan. This proposal would reduce administrative burden and substantially reduce some potential penalties, making them commensurate with the degree of a state's remaining non-compliance. Next slide, please. The seventh proposed change would clarify existing regulatory text about the allowability of costs associated with providing program information. The proposal provides some technical edits to the regulatory language to clarify the point that administrative costs exclude the cost of disseminating program information. For example, the cost of providing information pamphlets or brochures about how to reduce non-marital pregnancies is allowable under Purpose 3. And the cost of providing information about community resources to families experiencing economic hardships pursuant to Purposes 1 and 2 respectively is allowable whether or not the described community resources themselves are funded by TANF. So that is a summary of each proposal. We hope you will read the details carefully in the preamble text. I will now turn it back over to Lashira to close us out.
Thank you, Deborah. As we conclude, thank you all for tuning in today. We appreciate all that you do to support children and families served by the TANF program, and we thank you for your willingness to consider collective efforts to strengthen the program. We again direct you to the Federal Register to read the full text of the preamble and proposed regulatory changes, and to submit your comments by the deadline of December 1st, 2023. HHS welcomes comments through the comment process from all interested parties and will closely review and consider every comment it receives. The announcement for this webinar had a link to the NPRM and the Federal Register, and a URL is also listed that we provided in slides today. There is an option to submit a comment straight from the site. The link to submit in the federal e-rulemaking portal of regulations.gov is also included. We remind you that all comments received will be posted without change. Thank you for taking the time to review these proposed changes and provide your feedback as we all work toward the goal of strengthening the TANF program for the children and families it serves.